is reserved for the knowledge sharing. So today we are discussing about a very interesting topic, decoding term sheets, negotiating an investment deal with confidence. And as you have seen in our program, either we are telling the new law interpretation, or we are talking about the new law which government is planning to come. They want to ask certain questions. This time, how to do the transaction, what are the issues in the transaction. So this is also for enhancing knowledge of professionals and founders, startup, everybody who is connected to fundraising, fund provider. This topic is very, very topical and interesting for them. Friends, a term sheet is commercial proposal for an investment transaction, that how and why we are investing and what are the terms. So if you see the commercial aspect, that is the valuation. What should be the founder dilution? Because when he'll take money, he has to dilute his shares. What are the investors' right? Those who are investing money. What are the governance mechanisms in the company? What they will inform to the investor. Then exit mechanism. Then closing condition and drafting of definite agreement. In the entire thing, the most important thing is that how you will run the company, and if you are not able to do this, how the exit will take place. So everybody is very clear on some aspects. So this webinar will decode the glimpses and the nitty-gritty of term sheet from negotiating and risk allocation perspective. It will examine how term sheet provisions shape commercial outcome, because term sheet is not a legal document. It is talking about the larger picture. So this talks about the how the allocation of control will take place, how the economic distribution will take place, how the investor protection, execution pathways in investment transaction. Today you are investing X amount, tomorrow company requires more fund, then who will give? All these things will be the part of today's discussion. And we'll further focus on how drafting, choices and structural position influence deal certainty and the stakeholders alignment and long-term transaction outcome. So the good drafting can be a successful term sheet. Answer is no. The commercial drafting as well as a balance view can be a successful transaction, and that's why term sheet required. Because we have a various clauses. We will discuss today how these clause impacts, what you should focus. There are 100 items in a term sheet or an agreement. 10 items are important, all are noises. So are we focusing on noises, or are we focusing on 10 major items? So we will discuss that what are the important items, important tool, and important issues which influence various decision making, valuation outcome, control, fundraising in future, investor confidence, investor diligence, and structure of exit as well as closing. So today, the entire team will discuss our role and commercial significance of term sheet in investment transaction and deal structuring, governance, control, right, shareholder protection framework in investment transaction, founder position, including obligation, restriction, incentive, and liberty allocation, structuring and interpretation of investment instrument within applicable legal and regulatory framework, exit design, liquidity, transfer framework, and governing investment outcome, negotiating dynamics, drafting position, and risk allocation between the stakeholders. So negotiating dynamics, drafting outcome, and positioning and risk allocation between stakeholders. All these points today we will discuss. And for this, I welcome all our speakers today. First, we have Manoj Kumar, Partner Head, M&A and Investment Banking. Manoj has done more than 500 M&A transactions and involved in various agreement, negotiation, and the part of the term sheet. I welcome Manoj, and he will give his experience today after Ravi, Minali, and Varun will discuss because he has various example where the term sheet was not properly designed, drafting has taken place, what are the clause where they have faced problem. Then we have Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Profession. Ravi is also doing the transaction advisory. And then the transaction advisory, first point is that what are the commercial understanding? And then they convert to commercial understanding into a term sheet and then drafting of the agreement. I welcome Ravi for this program. Then we have Ms. Minali Jain, Senior Associate, Transaction Advisory, Corporate Professional. Minali is also looking after various ticklish and complicated transactions, and where she is preparing how they are doing, what are the issues they are facing, what the investor says, what the founder says. All these issues Minali will discuss. Then we have a Varun, Senior Associate, Transaction Advisory Team, Corporate Profession. Varun and Minali both are working in the same domain and advise client making agreement. Before agreement, they do the decoding term sheet. About that how term sheet should be drafted, how the term sheet should work. So we all will together decode term sheet and how it can be helpful for successful negotiation and investment. So friends, every investment transaction ultimately result in set of detailed legal documents. That is very clear. When we say term sheet mean something legal document. But how long before those documents are drafted and signed, the success of transaction is depends upon one fundamental instrument and one fundamental question, whether parties clearly agreed on the business and its outcome. So this is precisely where the term sheet assumes significance. It is not merely premium legal document or stepping stone of the final agreement. It is a written record of commercial consensus and understanding. It captures the understanding between the parties before lawyer begin drafting and set a direction to entire transactions. A well-negotiated transaction or well-negotiated term sheet creates clarity, balance, expectation, and build trust. It ensures that important commercial issues are discussed at the right stage rather than being left for future, and then you create disagreement which is become more difficult and costly to resolve. So today's session is therefore designed to go beyond individual clause, examine the larger architecture of the successful investment transactions, and it will help us understand how commercial clarity, practical negotiation, and future-ready approach can contribute to smooth transaction and a stronger investment relationship. I have prepared one small presentation on the basis of my experience of as a architect of various transactions and negotiation. So, friends, the decoding of term sheet. Now, I have an experience of 3 decades, and I have come across with various promoter, investor, investment banker, board on complex transaction. One lesson, which is very clear: commercial consensus create the future. Legal complexity will create some confusion. So I have seen so many people, what they do, they start agreement and then they correct it. So commercial consensus, if it's not clear and you start drafting, then it is bound to fail, bound to pay more cost, and then confusion. And then confusion is, and that sometime I have seen is also that the law firm and advocate and other people are saying, we have done this much of efforts, now you are changing, every time you are changing. So that's why there's a need of change. First, you should be clear on commercial consensus. 2-page, 3-page document of term sheet where you are finalizing the main point should discuss, devote time, and founder and other people should sit and then finalize. Each and every point they discuss. So good transactions are built through commercial clarity, not legal complexity. In the legal agreement, there are around 50% something which is common for all transactions. Now, this is not required that you should devote time on this, but we all discuss the main point we are discussing less, and we are discussing all other points. So a good term sheet is a tool that creates clarity. That is the most important aspects. Next. Now, redefining term sheet. Now, I'm giving what is the meaning of architect, or what is the meaning of legal. Legal drafting and the architect is a different. Are you drafting a agreement? Are you drafting a term sheet? Or are you architect of the transaction? So in the legal view, described as a preliminary document. But in architect view, it's a written record of commercial consensus. That is very, very important differentiation. Legal view is viewed as a stepping stone to the real contract. But architect view is capture the total understanding before lawyer begin drafting. The legal view is treated as legal chaos, then architect view is not merely a legal document, it is a business document. So if your focus is only on legal part, then you will confuse. But if you are focused on commercial part, so you will creating some document for future. The drafting on the basis of what understanding between both the parties, it is very, very sustainable and in long term, and every point which is important is covered. Because in term sheet, you're not writing the arbitration clause, jurisdiction, all these things are a common thing which are there where you're not focusing. You're focusing what is your my entry valuation, what is the exit, what is the governance, what are the compliance, what are the MIS you will give. All these points are a part of this. Tomorrow you require fund, how much fund, who will bring, then how the dilution will take place. All these points are there. So this we have to see next. Now, architect's blueprint analogy. Now we should understand why I am using architect's word. Like if you are making a building, so you are going to architect. So architect, those who are drafting term sheet, decide the structure, layout, and design by the term sheet. So if this building, this is the third step, the entire building is there. If building is not coming like this, building is coming when you are making complete plan from basement, the ground, and the basement digging to the top. What you will do, how things will take place, how you will manage the earthquake issues, what material you will put, how many floors are there, everything you are deciding in the commercial consensus. Second is the engineer, the lawyer, follows the blueprint of draft the agreement. So when this design is final, main point is final, BOQ is final, then lawyer draft the agreement. And last is the building, that is a transaction, it stands on the integrity of the design, because what you have decided initially, step one, it is the outcome of this. But if your first design is wrong, then your building will not come out. So if the commercial blueprint is wrong, which is step number one, the final building will always have a structural problem. That is a very, very clear note for everyone to understand this. Next. The broken order of the deal making. Now, what is happening? The flawed process, what is this? You negotiate partially. So, and then you start drafting. Assumption is that lawyer can figure out the gaps. Result is drafting cannot create consensus. So negotiate partially with this thought, then start drafting document and then argue over clause by clause. Because your understanding should be final, then the drafting. So only issue is this, that we have decided 50-50, you are writing something different. That argument can be placed, and then you go back to the original term sheet and then you finalize. So this is a flawed process. Look, people are doing this. But what is architecture view? Build commercial consensus. You take 5 days, 10 days, 20 days, no problem. but finalize the commercial consensus. Don't start drafting, start agreeing that yes, we are agreeing on this. Every transaction in two stages. First, people negotiate the business, then lawyer draft the document. Reversing the order is always a problem. So first build commercial consensus, then sign term sheet, and then draft document, and then execute. This is the best process which people should follow. Next. Now, these are certain structural hazard recognized deal breakers. Pitfalls, treating valuation as an entire transaction, that we have decided that this is the value of the company 100 CR and this is the transaction. No, ignoring the valuation is just one number in a much larger relationship. So how you can be successful is structure the holistic partnership, not just the entry price. So here, which I showed you the building is the final thing. Copy paste another company's term sheet. So many people are coming, "Arey, agreement ही तो बनाना है. I have this copy, you can just do." Assuming all deals, founders, their understanding, their way of working is common. All funding round is identical, or business growth is identical. It is not. Apply custom commercial logic to every unique transaction. Something people are doing, leaving commercial issue for later, avoiding friction during the initial handshake. So you are just, when you are making handshake, there is some doubt. And this is a forced clarity now. Delayed discussion usually become the biggest dispute in future. So many people have open-ended issues. You should not. Negotiating emotionally. Letting ego override business sense. So don't negotiate emotionally. Build a transaction purely on commercial logic. If it is advantage to both the party, the transaction will go. Otherwise, it will not. Next. Now, this is another important thing, the ripple effect of today's blueprint. The final mistake is thinking only about today's investment. A good term sheet must be tested against the future ripples also. So today's term sheet, what is the future due diligence? What are the things they will ask? The next funding round, what are the issue will come? A strategic acquisition you can do. In both the case, the dilution has to take place of the existing investors. Or you are asking other people also, the same people. So, and then there is a possibility IPO and exit route you're deciding today. Otherwise, my money will be stuck. If major commercial discussion continue after signing, the term sheet has failed its primary purpose, creating clarity and certainty. So that is very, very important point which we have to just understand. Next. The 5-point blueprint stress test, that is very important when you are deciding or dividing or making any term sheet. Number one, clarity. Will this create absolute clarity on how we work together? That is number one. Trust. Does this framework actively build trust between parties, or it is always some mistrust is there? Whenever somebody is doing something, you are thinking negatively to these people. Can both parties actually execute what is written? That is another aspect which we have to see. Then future ready. Will this next stage investor accepting these terms? That is another part. Dispute resolution. Suppose your transaction is not has reached to the dispute level. So if the dispute arising in 5 years, will the document resolve or it cause more dispute? These are 5 stress test blueprint we should follow. Next. The real cost of poor term sheet. If the term sheet is poor, then endless legal drafting, ballooning transaction costs, failed negotiation, again and again you are discussing on same issue. Then whatever you have decided, again you are, because new things will change, lost opportunity, that is another aspects. And then growing distrust, deep confusion and institutional delay. This is the issue. So biggest loss is not the legal fees which you are doing. Biggest loss is opportunity and the terms, time and trust. That is the most important thing which we have to see. Next. Redesigning the deal mindset. The founder's directive and investor directive, these are both are different. What founder wants, don't negotiate only for today's valuation. This is my advice to founders. Negotiate for next 10 years of partnership. Investor may change, founder may change, and market may change. But a well-negotiated blueprint continue to guide the relationship and the business which is there on that basis. What is investors' directive? What investors should do? A successful investment is not achieved by extracting every possible right. Because if you are not balancing, equalize, if you want to extract everything, if you are, I have my startup and you want 50%, 60%, 70%, then what is remaining with me? So sometime you have to understand that my investment should not be more than 20, 30%. And rest of the thing, money they require, I will put loan and I will put investment in this way. If you want to extract everything, the business will collapse. It is achieved by creating confidence. If investors are good, they create confidence. Otherwise, every time the investor will, the founder will think, I'm being cheated. Confidence create cooperation, cooperation create value, value benefits everyone who is invested in there. Next is the three load bearing pillars that is important in all term sheet. One is clarity. Everyone understand the deal exactly what is written, not the jargon, not the legal confusion. Balance. Everyone feels fairly treated by the mechanism of this deal. Both parties are thinking they are the winner, not they are thinking loser. Trust. Everyone believe the relationship can successfully endure. If these three things, three pillars are there, then you will find that you are successful or business will successful. Next is the macro perspective or ecosystem. The India's startup ecosystem does not merely need more capital. They are not asking more capital. They are asking a better commercial discipline. That is the important thing. Business will grow. Money cannot bring business. The discipline and the system and the business model can grow. Money can follow if you have something unique. So well negotiated term sheet reflect professionalism. That is very important. It immediately improves corporate governance. It escalates execution and build long-term investor confidence. And sometimes, if a term sheet is good, your terms are good, then I always feel the quality of founders' term sheet is the first test of their entrepreneurs. Its skill entrepreneur itself also. So you cannot say that you are bringing out a bad term sheet, bad rule, bad business proposition, and then I can have a faith in you that you are doing good business or you are a good entrepreneur. At the last, the ultimate takeaway is the best term sheet is not the one that legally strong. You drafted with the best lawyers. No, it is one the commercially clearest. Everything is clear. What is my investment today? What is my future requirement? How I will get information? What is the governance system? What is the our plan for investment, acquisition? Everything is clearly mentioned. If we are not working together perfectly, what is our exit route? How to exit? Whether this exit will bring down the business or it will continue and the payment will take in some step. Because if I have invested 30%, 40%, and I am saying I'm going, and the value is 100 crore, and I'm asking 40 crore, you give it to me. So the money is not there in the company. So how it will happen? Don't use a term sheet merely to protect your right. Use it protect the transaction. Because sometime when we make a term sheet, we just focus on extracting more or what is my right. If you are focusing that business is protected, growth protected, then both the party will get benefit. A successful deal is not measured by number of clauses that you have a 10 page, 20 page, 30 page, 50 page. I told you 10 points are important, rest are the noise. But by the number of issues that never become dispute because they were properly understood at the blueprint stage. That is the most important ultimate takeaway when we do this type of uh, term sheet. Now, friends, this is my overview. Now, Ravi, Minali, and Barun will talk. First, I will request Ravi to speak and tell us what are the foundation of term sheet matter, what they decide, how founders should choose a legally workable funding structure. All these points you have to tell. And before I'm giving to Ravi, I just want to inform our next webinar is on 17th July. That is next Friday. That is our 271st webinar on takeover code. We have not done webinars since long on takeover code. There are so many changes, so many things has taken place. So we'll discuss. Over to you, Ravi. Term sheets, safe and convertible notes. All these things you please tell us. Then Barun will speak about cover the economics and control of the deal, including valuation, dilution, and board and veto right, founders section, and convertible. Then Minali will discuss about the exit economics and information related control, including liquidation, preference, transfer right, SAFA, and ISFA. So over to you, Ravi, for this. Please explain.
Thank you so much, sir. I think this noise and signal example is very important. Certainly, negotiating a term sheet or a deal or any transaction, I use these words interchangeably because one leads to the another. And if there is a transaction, what matters most are the terms of it. And I think the name itself makes it very explicit that this is a document that contain those terms. And those terms are nothing but the consensus between the parties and their commercial understanding of it. But then there remains a problem. When the noise and signal both comes from the music that you are playing, which is the transaction, it is difficult for one to filter out the noise and signal very clearly. So I think the message of Sir was to anticipate not only what is visible today, but something that can have an impact in future and mitigate all the adverse impacts, not only for you or the counterparty, but for the business and the transaction itself. Without much ado, let me just begin with the topic of the day. Why term sheets matter. A person who understands the value of business is going to negotiate much differently than the one who does not understand it fully or who has not done the proper homework. Usually, the noise and the loudest one is about valuation. Well, that is an important factor. But valuation does not mean that one has to negotiate only for a higher valuation. It means and requires a deeper meaning, which is to understand the complete bargain. The real question, therefore, would not only be what valuation a business gets, but also for the valuation and for the incoming money or investments, what all it is going to give up today and what all will be impacted in posterity. So a term sheet, basically, as you can see on the screen, on the slide itself, it may decide and can decide, and I'm sure it must also, that how much the founder actually owns after an investment round, who will control the board and veto decision, which falls into the realm of governance, whether future fundraising will remain clean or it would become difficult. There would be questions on future investors coming into the company. Would the business itself remain lucrative for future investors? How the exit proceeds will be distributed, whether investor disputes can arise, and on what all aspects, and most fundamentally, what are the instrument mix and conversion mix that is being used, and what sort of rights are weaved into the term sheet. Well, many a times there is a misconception that negotiation means, as Sir also said, extraction. Well, negotiation, unlike extraction, is not a zero-sum game. It does not have to be the fallacy of slippery slope where either it is all or nothing. Negotiation in itself is rooted in pragmatism, not in false urgency, and neither in a pseudo bravado. So therefore, what one must see is whether the clauses or the mix of rights which one agrees to can have compounding effect over dilution, control, future investment entry, valuations, and exit outcomes. Because two investors may agree to enter into a business at the same amount of valuation, but the commercial outcomes for both and for the business may be completely different, especially when one seeks basic information right and the another one seeks the entire buffet of it: board right, white veto right, anti-dilution protection, preemptive rights, virtually strangulating the very business in which one is investing. So therefore, the message, I think, which is very loud and clear in the presentation that Sir gave, is that negotiation should not be seen as an exercise between two people who are on the different ends of needs and wants. It should be seen as an exercise through which a sustainable and valuable business outcome or an economic outcome can be achieved. So therefore, before signing a term sheet, a founder or whosoever is responsible leading on the term sheet, especially from the investment side, investee side, must ask what would be the effective dilution, if at all some pool of ESOPs and other convertibles are being created, see whether it would be pre-money or post-money, what decisions will require investor consent, what is the governance model one is entering into through that term sheet or transaction, who can block the next round, whether it would remain clean or it would be subject to certain approvals. What happens if a company exits at a moderate valuation? Can the company do a down round? If yes, then at what cost? So there could be innumerable factors, but I'm just telling few of those which would strike a chord with the one in audience. And with this, let me just move on to the next slide. So the next question that arises naturally is, where does the term sheet sit in a deal cycle? So let's suppose a founder has made a pitch, the investor has shown interest, some information has been shared, there is broader agreement between the parties as to the understanding where they are going to invest, but a detailed diligence is still pending. Definitive documents have not been made and they have not been agreed upon also. Corporate approvals, closing, and all other conditions are pending. Now, here is the stage. This is the juncture where the term sheet enters. The investor has enough interest to anchor the terms, but the founder may not have received the entire visibility on detailed legal, tax, and structuring advisory, or in its proper sense, structuring first and others to later. Anything that is left vague here in the term sheet stage, which is before diligence, before definitive agreement, before closing approval, and before the money actually comes in, may create a cascading effect of things opening up when you move towards the transaction, and ultimately may lead to a deal breaker situation. If one cannot anticipate how, based on the outcome of diligence, what would be the red flags, how it would be adjusted. If negotiation leverage is not taken fully, it may create confusion. So one thing, in fact, not one, there are five, one must be very clear with, is the dilution, the instrument, the governance rights, exit economics, and closing conditions before one invests. And why it matters, why the term sheet matters, because it fixes one valuation assumptions, or at least gives a roadmap about it. If you cannot anticipate that well that you can see the next decade, you can at least root the valuation assumption. It also decides the instrument mix or structure. It decides on the broad set of rights, what rights, especially at the genus and species level. If not all the rights, it can certainly tell what genus of rights will be covered and what would not be. And it gives the drafting instructions. And why only for the lawyers? It also gives broad consensus. It also records broad consensus between the parties. And because the term sheet metamorphosizes into a transaction document, definitive document, it is going to stay, even if the investment would go bad, the term sheet and the transaction it yields into is going to stay permanent in the life cycle of a business. Next slide, please. So one of the usual misconception that we come across while discussing it with founders and businessmen is that they feel, and one is very keen to enter into a non-binding term sheet without understanding fully that the label does not decide the nature of an instrument. A label is at best an indication, a dress of the document, but not its substance. So if one enters into a non-binding term sheet, there could still be certain clauses which would be seen as binding. For example, exclusivity clause, confidentiality clause, dispute resolution, governing law. All these clauses are of such nature that either they would exist, or they would become adhered to, or they would not be adhered to, in which case there would be a breach. Unlike valuation. Valuation may change subject to finding of diligence. How much amount has to be invested will then be latched on to the valuation. So all those things, then you see there are certain commercial terms that can be changed, that can modify subject to the transaction life cycle and how it proceeds. But then there are certain terms that do not modify. Either they are there or they are not there. And if they are there, they bind. So binding carve-outs must be tightly drafted. Conduct after signing may become relevant, but this does not give discount that one has to not bind the language properly. Governing law arbitration clauses, these clauses require precision. And as I said, while one may perceive it as non-binding, disputes may still arise. And one of the famous case dealing with this, although many big conglomerates have also gotten into trouble because of these, and to name PVR, Gale, all these would be companies where cases are there regarding term sheets. But one example that comes really handy is of Oyo and Zostel. They had a problem of whether it is binding or not binding. That was the key controversy. I'm not going into too much technical details. The controversy was whether the term sheet is binding or not binding. The arbitrator gave a finding it was binding. The High Court, when it reached, they said, oh, it's not binding, barring certain clauses. And those clauses were these: exclusivity, confidentiality, dispute resolution. Because you cannot create a contract which would not give any remedy to a party. There can hardly be any contract. So the drafting discipline, and before that, the structuring discipline is paramount. One must understand, even in a non-binding term sheet, what provisions can bind them. What are the condition precedents, long stop dates, termination rights, scope of exclusivity, and its period. And as I said, the governing law and arbitration clauses. Next slide, please. So once you start looking at term sheet from the perspective of an architect, or in its fuller sense, you would see term sheet does not only contain terms that can be reduced to writing with alphabet, combination of alphabets. It also decides the economics of a transaction, who is going to control the economics as well as the governance, what would be the exit provisions. And then it also weaves into, as an implicit requirement, of compliance, because a partnership can hardly issue equity shares. So even if you draft a very nice term sheet and say that partnership is going to issue convertible notes or CCPS or equity shares, that is certainly then not going to work and might land parties into trouble. So with this, I would now welcome my colleague, Mr. Varun Litoria, who would tell you about these two crucial and critical aspects of economics and control. Mr. Litoria has advised many startups and companies alike on structuring these conditions aligned to the commercial objectives of a transaction, as well as with the broader legal and compliance requirements. Over to you, Mr. Litoria.
Thank you. Thank you for having me over here. That was a very generous description. So thank you for that as well. So we are moving towards the clauses, how they are dealt with specifically within a term sheet. So our first clause is a clause which deals with investment amount, the valuation that you will be writing over there. Although valuation you might write in the instrument related mechanics and the process of it as well. But herein what we are trying to show you is that if you see the aggressive investor clause, specifically it is written that the ESOP pool or something of that something like that will be done before investment comes in a company. What does that mean? Well, it means simply, suppose an investor is coming in your company. It agrees to invest 5 CR in your company. And now investor is asking, before I invest amount or you issue any securities to me, you please make sure that you hire the right talent and create an ESOP pool for them. Why investor is asking for that? That's the main question that you need to ask. Investor is asking this particular ESOP pool to be created before the issuance of securities to that particular investor is because of the fact that if we create ESOP pool after the issuance of security to the investor's stake might also dilute. So because of that particular nature, the investor might ask you and will generally at a term sheet stage, whosoever is giving the first draft will try to anchor their clauses or terms that they want and will keep the terms broader for themselves in favor of themselves, so that if in case you wish to negotiate tomorrow or if you wish to state your terms tomorrow, they will have ample room to put their hands on. So keep in mind that you specifically state what will be the instrument, what will be the investment amount, what will be the pre-money value, post-money value, when the ESOP pool will be created, how it will be adjusted, and eventually it will be an impact on your cap table. So moving on to the next slide. It is the instrument selection. This is a very interesting slide. So generally for a founder or a company who is at a seed stage or a pre-seed stage, or even at the seed series, investor, if they find that the company is doing well, but there are stuffs that for which they want to do due diligence. So they might ask you that today I am okay with getting a CCPS or CCD or whatsoever it may be. But tomorrow, based on the due diligence, if anything comes up, I'll have the right to choose any other form of security that you can write down in the definitive document. By definitive document, I mean shareholders agreement, share subscription agreement, or SSHA, whatever the case may be. So investor will definitely will ask you that I am doing the due diligence right now. Although we have written it, the type of instrument that is supposed to be issued to that particular investor. So investor will ask for a particular right that tomorrow he can change it based on the due diligence finding. But why you should not do that? You should not do it, and you should confirm that whatever instrument will be issued in the definitive document today, because it will elongate the legal process also for you. It will elongate whatever you need to do as a condition precedent at a closing actions. Whatever you require to do today will be stated in your term sheet broadly and will be catered in your definitive documents as well. If you decide the instrument today, it will accordingly be, your whole deal will be structured accordingly. So you have to specifically decide the instrument very precisely. Moving on to your next slide. It is the condition precedent and closing that we were talking about. So specifically, if you see in both the clauses, I've highlighted one of the clauses and one particular portion of the clause that particularly states that investors shall not be required to complete the investment unless the definitive documents are acceptable to the investor and all the identified conditions are completed to investor satisfaction. While if I ask you, what exactly is investor satisfaction? Isn't it very subjective? So that's why you specifically have to have a schedule, or you have to clearly state what will be your condition precedents, what will be your closing actions. It why specification and precision is required while writing term sheet is because tomorrow, if anything you have written vague, the other person will ask you that, see, it was broad enough so that tomorrow if something uncertain happens which we don't know, we can take care of that. But that's not the case. If something uncertain happens, it is your company, you are the founder, you will definitely would like to do that. But having certain things specific would not end up getting you involved into a dispute or renegotiating your term sheet. So having specific condition precedent of closing actions would definitely help you. Moving on to next slide. Board seat and board observer. Here and after I'll deal with reserve matters also. But why this specifically is the talk of the town? I'll just tell you. See, today there is an investor A in company X. Investor A is investing 10 crores for 10% of that particular company. Tomorrow, after so many rounds, that particular investor has around 2% or 3% of stake in your company. And there are other institutional investors that are currently having a much higher stake in your company and adding value to your company. So, but that at that particular stage, when you are signing that particular term sheet, or signing a definitive document, you need to define a particular threshold that since if you have a, let's say, a threshold of 8%, if you have a shareholding in my company, 8% or above, you will be having a board observer seat or a board member seat, as the case may be, and as the investor may ask you. So, why defining threshold is important? Today, you are at a seed series round or a pre-seed round. Today, this particular new investor is very important for you, but you have to go through a long life cycle. There will be more funding rounds, there will be strategic rounds. Thereafter, might be if you are thinking for an IPO. So till that particular round, you will be might be going through 6 to 7 rounds of funding. And during those rounds, your cap table will change, the shareholding will change. People who were important earlier might not be important today. So accordingly, a threshold needs to be defined so that you have the right people on your board. Accordingly, you need to understand difference between an observer and a board member or a director, if I say. Basically, generally, a investor would ask that I need to have a right to appoint an observer or a director, which they, if they appoint, the observer would generally observe your meetings and will ask for the materials of that particular meeting. In other case, the director might be taking decisions for your company or putting in a vote. Now comes, there is a small thing that I would like to highlight, possibly not written in over this slide, but something that you should always remember. Always remember one thing, that the board observer should not have a shadow control over your company. Tomorrow, board observer should not start influencing your board, telling you or giving you directions that see, we should do this. Why? Because I have seen this, or something of that sort. So you should keep that in mind. Whosoever you are providing, whatever position, you have a proper boundaries set, you have proper expectations set, so that tomorrow if anything happens, you have clearly written down what they can do, what they cannot. Thereafter, moving on to the next slide. Reserve matters. As I was talking about, reserve matters tells you about specifically tells you about the kind of matters in which you need to take consent of an investor. Now, reserve matters should be there. It's not a problem, because if I am today investing in a particular company, I am concerned about the money that I'm investing, whether I'm getting an appreciation in the investment amount that I'm. So it's not against the investment and it's not against the transaction or the founder. What you should definitely keep in mind is first the threshold, that if an investor is having this particular percentage of shareholding in my company, they have a right over these particular matters. What these particular matter can be, they can be related to change in business, any particular decision with respect to lending, which is more than a particular threshold, maybe any related party transaction done not in ordinary course of your business, or other things that specifically will have an impact on the investment of the investor. What it should not have, your day-to-day operations related matters, your ordinary course matters, or such other matters like ESOP related matters, or matters related to terminating an employee, appointing an employee, kind of business or like daily basis expenses and everything. These kind of things should not be covered in the reserve matters list. So keep in mind, whatever you are writing in reserve matter, are they directly impacting on the investment amount that the investor is putting in your company? And is there a threshold which you have particularly written that the investor of this particular shareholding will only have this particular kind of veto right in my company? Moving on to the next slide, founders lock-in. Many founders think that a founder lock-in clause is a anti-founder clause, while it's not the case. The case is that during the early stage of a company, it is not the bet on the company that the investor is taking on. It is the bet on the founders. It is the bet on the product. So the investor would like that the founder would stay in the company. They would not leave the company aloof in between the life cycle of the company or until they get the exit. So the founder would like to have a lock-in period on the founders that you will stay for these many years at least in the company. Or while if I talk about aggressively, an investor may ask you that, see, I'm investing in your company, but this investment, I'll not take an early exit from your company, or you cannot leave the company till the time I do not take exit. This is a very broad based defined period. You don't know today when the investor is going to get exit. You don't know when you can actually provide investor an exit. You don't know the time period. Maybe valuation based, you can define what can be a exit amount, but that is not a definite answer also. So have a definite period in your term sheet that the founder lock-in period will be applicable for these many years. Let's say for 3 years, for 4 years, or maybe 2 years. Totally dependent upon at what stage the company is, and also how much period has already been passed since the founders are already being in the company. Moving on to the next clause. It is completely related, and it is the founder's vesting and leaver treatment. So basically, the founder vesting or leaver treatment, what it is and how it is related to the founder lock-in. As I have told you about founder lock-in, the founder vesting part is, suppose you have 50% stake in the company as a founder or a co-founder. Now the investor is coming in. It is asking for a lock-in of 2 years and asking you that that 50% of your stake, which means the 25% shareholding of yours in the company, will be vesting over a period of 2 years till that period of lock-in gets completed. What does it mean? That means that the investor will ask you that these should be your targets for coming 2 years or coming six half-yearly targets, 4 half-yearly targets in the 2 years, which you need to achieve. And accordingly, the 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 shares which you already had, they will start reverse vesting in you. Again, one more concept which is very important, which is the concept of a good lever and a bad lever. What does it mean? Seems very fancy. So it is related to if a founder leaving company early during the lock-in period. Suppose, let's talk about good lever first. So suppose if due to a disability or due to death or any kind of a good faith reason because of which founder is not able to continue with the company and wish to leave the company. In that particular case, the unvested share amount or percentage, which we were talking about, which was 25%. Let's suppose that 25% was unvested shares. Those 25% unvested shares will belong to the founder itself when that particular founder is unable to continue with the company, and the company will give that particular, as per the valuation of the company, particular amount of 50% of founder shares in the company. While in case of bad lever, maybe a fraud being committed by a founder, maybe something else, misconduct, negligence, as you may define, moral turpitude, or something like a bad lever, which you have defined in your term sheet or your founder co-founder agreement. When you have defined it and a founder does it during the lock-in period, those unvested share percentage will belong to either the company, either to the co-founder, or the investor will have right over it. But having said that, you have to define your right that during that particular period, if there are unvested shares and you turned out to be a bad leaver, the right who's right who will have the right over those percentage of shares, whether it is investor, your co-founder, or the company itself. Moving on to the slide, which relates to anti-dilution protection. So let's take the same example which we have been looking into. The investor has invested 5 crore in your company on the face value of 100 rupees per share. But it was a convertible instrument. So investor hasn't got any particular equity share. It has got a CCPS, which are supposed to get converted in the next financing round. Now the next financing round or the next funding round, as we may call it, what happens? The valuation of the company comes down and the new shares that are going to get issued are of rupees 60 rupees. Now, the earlier investor is saying, see, I invested at a higher valuation, and considering you incurred certain losses because of your valuation has gone down. Now you are giving same kind of shares to other investor at 60 rupees. You have given it to me for 100 rupees. So I need my anti-dilution protection, which I have written and you have signed and said it in the term sheet that you will provide it to me. So this anti-dilution will come into the picture that time. So in case of a down round, there are two kind of anti-dilution that may work. You have to decide what you should keep in the term sheet. Ideally, people generally keep a broad-based weighted average formula in the term sheet. And it is helpful for the founder and helpful for the investor. It is a middle ground that the formula is providing to both the parties. While in case of a full ratchet, which an aggressive investor may ask you, in that particular case, full ratchet will provide exactly the same amount. So the example that I've given you, in case of a broad-based weighted average, the investor might get the new shares or the converted shares at price of 80 rupees, let's say. But in case of full ratchet, the investor might get at the same 60 rupees price as the new investor is coming in and getting the shares in the company. So this was anti-dilution protection. Now moving on to preemptive rights, it's very similar to anti-dilution right, but there is a only single piece of difference which differentiates the preemptive rights from the anti-dilution right. Anti-dilution applies in case of a down round, while preemptive right applies in the next funding round, but that's not a down round. So your preemptive right gives the right to the investor. Like let's suppose investor is liking how you are running your company, how company is growing, how founders are taking care of the company. So they want to have this right on in their term sheet or in their definitive documents that see today I am taking in 10%, but I would like to maintain my shareholding in your company, and going forward I would like to exit at 10% only. So you give me this preemptive clause, which provides me the right that I can purchase extra shares at the same valuation of the next funding round, same as the new investor is coming in. And so that I can, you need to give me only those number of shares so that I can maintain my shareholding in the company. So that's what a preemptive or pro rata rights are about. Now it is about liquidation preference, which my colleague Minali will be taking care of. Move over to you, Minali.
You'll have to unmute Minali.
Am I audible now?
Yes, loud and clear.
Yeah. Thank you so much, Varun. Your session was really insightful. Like, I hope everybody attending this particular session would have clarity with respect to the terms that you explained. Now, this particular clause, which is liquidation preference, it basically decides who gets paid first whenever there is any liquidity event. When I talk about liquidity event, the events that are generally included are dissolution, winding up, merger, sale of all or substantially all assets, change of control of the company. The investor would want downside protection
Huh?
while the founder would want to ensure that investor protection does not wipe out the founder economics. So let's see how we can find a via media. The standard and the market balanced position is that the investor gets the higher of the two outcomes. If you see on the screen the highlighted portion, so either the original investment amount back or the amount the investor would receive if the convertible security gets converted into equity. Let's try to understand this particular, like either of two concept through an example. So let's suppose an investor invests, let's say 5 crore rupees. Later, the company is sold. The investor will check, do I get more by taking back my investment, which was of 5 crore rupees, or do I get more money by converting into equity and taking my percentage shares? The investor gets the better of the two, but does not get both. Also, when I say the investors doesn't get both, so there are types of liquidation preference. Like for example, there can be participating and non-participating liquidation preferences, uh, which basically means, when I talk about participating, it means that over and above 1x or converted money, the investor is also getting right to participate in the remaining proceeds in the proportion to its holding. Now, when we read about the highlighted portion, you can very well see in the second and third line the 2x and 3x. So, if the investor asks for 2x or 3x participating liquidation preference, the investor first takes 2 or 3 times its investment and then also participates in the remaining proceeds that can seriously reduce what founders and ordinary shareholders receive. This is also one of the important clauses which should be drafted and negotiated very well, as liquidation preference decides the exit payout. Then, after the exit payout, it is important to see how you can actually exit and what all rights related to exit are there. Moving on to the next slide. Then, when we talk about transfer rights, there are certain terms of which we have, like maybe many of you would be having a brief understanding. So, let's try to understand these terms first. So, starting with ROFR, it basically means right of first refusal. If a founder finds a buyer for his share, the existing investor gets the right to match that offer, and if the existing investor matches the offer, the founder is required to sell its shares to such existing investor. Now, when I talk about ROFO basically means right of first offer. Before the founder goes to an outsider buyer, the founder must first offer his share to the existing investors. So ideally, ROFO and ROFR are the rights that are applicable when maybe the investor or maybe the founder are doing secondary sale. Then moving on to tag along, it protects the investor. If founders are selling their shares, investors can also participate in that particular sale so that they are not left behind with a new shareholder or changed control structure. Considering, like when the investor got onboarded, they believed the founder or believed the promoters on whose face value they entered into the company. However, in case moving forward there is any merger, amalgamation, change in control, so they would want a chance to an exit. So along with the promoter shares, investors also tag along with the founders or promoters and would want an exit. Now, moving on to the drag along rights. Drag along works in the opposite way and is also used as an exit mechanism when the founder is unable to provide exit to the investor. The investor may identify a buyer who wants to acquire the company and drag the founders along to sell their shares to such buyer. For example, drag rights should not allow an investor to force founders to sell at any price to any buyer and with unlimited personal warranties. That is very aggressive. A founder should ask for safeguards such as only an investor with certain percentage of shareholding in the company can use drag rights. The buyer should not be a competitor. A minimum valuation or return threshold and limited founder representations, warranties, and indemnity should only be given. These rights are commercially important. However, while giving these rights, it's important to keep an objective mind and include guardrails. When I say guardrails, I mean whenever you are giving such kind of representations, warranties, whenever there is a drag sale happening, it's important to keep either a schedule or to keep like maybe in case there is any breach, or limit your representations and warranties only with respect to the title, of which we'll read detail in the representations and warranty clause. Now moving ahead with exclusivity. So basically, exclusivity or no shop clause means that for a defined particular period after signing the term sheet, the company and the founder agree not to solicit or to negotiate a competing fundraise. This is important as already, like most of you would have heard, that this particular commercial term in the term sheet is, even when the term sheet is non-binding, it comes under the binding terms, which was even highlighted previously by Mr. Ravi. So exclusivity is usually drafted as a binding obligation. So why, let's understand why it's basically done. What's the rationale behind it? The investors rationale is very understandable, because they would be end up spending their time, their cost on maybe due diligence, on documentation. So they does not want the company to use their particular offer to obtain a better bid. The founder risk begins when exclusivity is very open ended, for example, until closing or until the investor decides to terminate. Mostly the industry standard of this particular duration is 30 to 60. However, depending on what kind of term sheet it is, what the subject matter it is, this particular range as per the industry standard may differ. Moving on to information rights. Information rights generally allow the investor to monitor their investment at a reasonable level. This is completely justified. Investors should receive quarterly financials, audited financial accounts, annual budgets, business plans, etc. The issue starts when information rights become too broad. If an investor asks for daily MIS, bank statements, customer level data, employee data, vendor details, and unrestricted inspection rights, that can become very operatively heavy for the founder. For example, if a founder has to already see like maybe day to day things that the company has to do, and then like gathering all those particular data MIS and giving it to investor, and then answering the questions that the investor asks, it can become operationally very tiring for any kind of founder. So it can also create some confidentiality concerns. This is especially relevant where the investor has portfolio companies in a similar sector. So the founder should not resist information rights altogether, which is not practical. The founder should instead make them maybe periodic, purpose based, and confidentiality bound. A good position is provide information for monitoring the investment, not for unlimited market mapping or operational interference. Information rights should support investors' oversight and should not become shadow management. That brings us to representations and warranties, where the key question is not only what is being confirmed, but also who bears the liability if that confirmation is basically incorrect. when we talk about representations and warranties. Representations are basically a set of statements that are given by the promoters or the founders, and warranties are basically the promises based on which the investors relies while entering into the transaction. At the company level, they are generally they generally cover information with respect to incorporation, authority, capitalization, compliances of law, taxes, intellectual properties, etc. If a statement is inaccurate, it may trigger a contractual indemnity or damage claim. For example, if key software was developed by a founder or consultant, but the intellectual property was never assigned to the company, a broad warranty that the company owns all its intellectual property may create a post closing claim. What we suggest generally is to have a disclosure schedule, known exceptions such as pending notice, tax, dispute, unregistered intellectual property, or an undisclosed commitment should be specifically disclosed so that the relevant warranty is appropriately qualified. A founder should not sign an absolute statement merely because the parties expect to correct the issue later. The aggressive position is where every founder gives all company warranties jointly and severally. So the words that you will be looking for in an aggressive term sheet should be uh, all the founders and the company jointly and severally, like represent and warrants. So not all the business related warranties and representations should be given by the founders. Try to create a different representations and warranties for companies and founders. Ideally, the founders related representations and warranties would be linked to maybe their title, in case they have any uh, personal IPR in their name. So maybe related to that, then maybe specific matters within the founder's actual knowledge or control. Then any indemnity related to the representations and warranties, or even otherwise. Like, this goes everywhere, irrespective of whatever the subject matter of your term sheet is. uh, Try to have guardrails whenever it comes to indemnity, like maybe a liability cap, a de minimis threshold, or a basket, a survival period. uh, Due to crunch of time, I would not be able to explain like what a liability cap would mean, what a de minimis threshold or a basket. But in case any one of you is interested, I would really like plead to just give it a read, because like these are certain terms which might be actually useful in case you are thinking of having drafting a term sheet or even a definitive document. Let's move to the concept of safe. So SAFE basically means simple agreement for future equity. The very easiest way to understand SAFE is that the money comes now, but the shares will come later. Ideally, this concept has been originated in US. An investor gives money to the company today. The investor does not immediately receive shares. There is no interest, no maturity date, and no standard repayment obligation like a loan. So it's basically not a debt instrument. It's not basically a loan. Then the safe converts into equity when a future trigger happens, which usually is a priced financing round, acquisition, or liquidity round. When I talk about price financing round, it can also be called as maybe a qualified financing round. Now let's understand the concept of safe through an example. Assume that there is a startup which is too early to be valued today. The investor still wants to invest. Instead of debating over the valuation for months, the investor gives money under a safe. Later, when a proper price round happens, the safe converts into shares based on agreed terms, such as maybe valuation cap or discount. It sounds good, however, SAFE works very well in the US market, but the same document cannot be imported blindly into India, because any working should be within the four corners of the wall and of the legal structure. So there are certain things which are not allowed in India. So moving on to the next slide. Why original safe does not work in India? Let's try to understand why a pure US style safe does not work in India. So, a pure US safe is basically a contractual right to receive shares in the future, but Indian company law and FEMA do not work comfortably with a loose contractual right to future equity.
Nitish, बिल्कुल से बात उससे बात कर. Sorry.
No problem.
Carry on.
In India, when a company raises money, the instrument generally mapped to a recognized legal security, which could be either equity shares, preference shares, maybe debentures, maybe convertible notes in eligible cases, or other recognized instruments. If an Indian company simply receives money today and says shares will be issued later whenever something happens, it may be treated as deposits, as we may run into Companies Act, deposit rules, FEMA issue, if the company is a foreign entity. Then the Indian question is not only what does the safe say, the question is what security has actually been issued and under what compliance route. So, this is where iSafe comes in as an Indian adaptation. iSafe, moving on to the next slide. iSafe is the Indian adaptation of the safe economics. It tries to preserve the commercial benefit of safe, which is quick money, deferred valuation, and future conversion, but places it inside an Indian legal framework. In practice, Indian iSafe structures are often built through a CCPS wrapper. That means the investors get a recognized security, usually compulsorily convertible preference shares, but the economics behaves like a safe. So the company gets investment now, the valuation may be deferred or protected through a cap or maybe a discount or MFN. In the upcoming slides, we'll also understand what these terms actually mean. Conversion with respect to iSafe happens on a qualified financing um, round, or maybe some liquidity event, or maybe any other agreed trigger which would be agreed between the parties. Then when we talk about what are the types of iSafe, moving on to the next slide. There are broadly four types of iSafe structures which were introduced in India by 10x, which is a VC in India. These types are valuation cap, discount, valuation cap plus discount, and MFN. Let's try to understand what each and every structure or type means. A valuation cap means the investor will not convert above a certain valuation. If the company's future valuation becomes very high, the early investor still converts at the capped valuation. A discount means the investor converts at a cheaper price than the next round investor. For example, if the next investor pays, let's say, 100 rupees per share and the discount is maybe 20%, the iSafe investor converts at rupees 80 per share. The valuation plus cap discount means the investor usually gets whichever is better, the cap price or the discounted price. For the investor, the objective is to get a lower conversion price, because lower price means more shares. For the founder, the concern is the opposite. Lower conversion price means more dilution. So it's important to choose the right type if opting for iSafe. Lastly, MFN means most favored nation. It does not give any direct price today. It says that if the company later gives any benefit or maybe better terms to another investor, this investor can also adopt those better terms. The simple distinction is that cap and discount are basically pricing protections. However, MFN is a parity protection. Let's now try to compare and understand what is the comparison between iSafe and the price rounds. The simplest difference is that through an iSafe, one can postpone valuation, while in a priced round, upfront valuation is required. The investor receives shares, and the rights are mostly negotiated upfront. The cap table impact is visible immediately, but the process is longer and the documentation is also heavier. So iSafe is useful generally when the company is very early and the valuation is difficult to determine. It helps founders raise money quickly without spending months negotiating a full SHA, SSHA, or whatever definitive documentation you are thinking about. A price round is better when the company is more mature, the check size is comparatively larger, and investor wants governance right. Board rights, reserved matters are there, liquidation preferences there, and investors require full-fledged documentation. Excuse me. In an iSafe, money comes in very quickly. Documentation is also comparatively shorter. Diligence is also lighter. But dilution is not visible on day one because the conversion eventually happens on a later stage. iSafe gives the company or the investor speed and flexibility. Price rounds, however, on the other hand, gives certainty and governance. For founders, the decision should depend on what kind of stage the company is in, what the check size is, what the investor profile is, what the compliance readiness of the company is, and whether the company can even justify a valuation today. So we need to understand that no instrument is automatically like good or bad, or this is what everybody is doing. You need to understand like what you and what your company requires today. So now Mr. Varun will be discussing about convertible notes. Over to you, Varun.
Hello. Yes. So, Varun,
Yes, sir.
anything is left out from your side?
Yes, sir. Only the convertible notes part.
Okay. So, you want to cover it out after the Manoj sir?
Sure, sir. Sure, sir. We can do.
Okay, Manoj.
Yes, sir.
Now you have done
Good
so
evening.
many transactions. Okay.
Right.
And you have done M&A transaction, you have done the deals also, family settlement also. You are doing the transaction as a merchant banker. You are doing a takeover transaction. Everywhere you are doing any transaction, multiple things, you are making a agreement. Now, what I started in the beginning, that any agreement which we are making, if it is not clear on terms on the commercial terms and noted down through term sheet, my suggestion which I have given my presentation, it is always create problem. And
Right.
I have seen the people, and you have seen so many transactions where promoter comes that मैंने अपनी टीम से ये agreement बनवा लिया है, okay, and they come and they say बस आप इसको ना bet कर दो.
Right.
And then when you are discussing with the other party, they are saying, no, this is different. My understanding is different. So what message you want to give to the entire professional circle and the promoter and as well as the investor, that what the best way and where are the issues which is always affecting the transaction?
Thank you very much, sir. Good evening to everyone. I think Varun, Mitali, as well as Ravi has given a very elaborate discussion on each of the important point of a term sheet. Obviously, these are the basis on the basis of which the detailed definitive agreement would be created. So definitive agreement obviously goes on in hundred of pages sometimes, but this commercial understanding must be in the form of term sheet, and term sheet should be because the term sheet is basically the commercial blueprint of a transaction. I'm not talking only about the investment term sheets. It may be investment or maybe M&A transactions. In all circumstances, the first document which is signed between the parties is a term sheet. Sometimes it is written to be binding, sometimes it is written non-binding. However, practically people are acting like binding thing. So, and I think Ravi has given the example also that in sometimes it is, whether or not it is written as non-binding, it can be treated as binding. I think there are a couple of legal judgments also on this aspect. So we have to understand that the document, which is this term sheet, is the primary document which sets the commercial blueprint of the whole transaction. So core things like valuation, structure, dilution control, risk allocation, exit related things, closing certainty, etc., should be clearly mentioned in simple language, simplest of the language, which can be understood by both the parties in the same way. It should not be 6 for one and 9 for other. That is the biggest problem. Whenever something is left out, it creates a problem at the time of drafting, because lawyers can act only based on this term sheet which is agreed upon. And most of the times, term sheet are not drafted by lawyers. And that creates a lot of problem because the language sometimes is very vague or something is left out. Like in case of valuation, I have seen many of the transaction getting not materializing during the final drafting stage because of the certain terms like adjusted EBITDA. Valuation is X multiple of the EBITDA is decided, and both parties agreeing to that. But what all adjustments are allowed and not allowed is not written. Similarly, then the EBITDA is of what date, cutoff date, it is not written. It is agreed that okay, 9x of the EBITDA will be the valuation. But what 9x mean to one, maybe just before the closing date, they will say, okay, oh, my profit has increased, so I will agree on this valuation. I have seen a big deal getting broken between two big listed entities only because of this terminology. What was the date on which the EBITDA to be calculated? Then relating to adjustment on the working capital. So net working capital, standard working capital, everyone understand that there is a working capital, and that working capital can be added back to the valuation if it is surplus. If it is negative, it has to be reduced from the valuation. But whether it will be on a particular date or it will be treated as based on the last 3 years, 5 years track record. So these kind of smaller things which creates problem at the time of drafting and agreement between the parties. Similarly, dilution related other things like ESOP, like Varun has clearly said that ESOP pool in most of the startup or funding rounds, investor wants that there will be some pool for investors, ESOP, and that creates extra dilution to the founders, which creates a lot of dispute at a later stage because they are not assuming this kind of thing would come. Then there can be a lot of issues relating to the diligence. What all things can be adjusted or cannot be adjusted in the valuation. So these are the smaller things which is not captured in commercial non-commercial binding or non-binding term sheet. And at the time of negotiation of final term sheet or valuation gaps come, disagreement comes between the parties, and that breaks the deal. So I have seen many of the deals are going haywire at the time of final drafting stages when the lawyers sit together from both the sides and they negotiate on these things, and they don't agree because nothing is clearly written in the term sheet which can be fallback arrangement for those lawyers. So we have to be very clear. I think that is more important for the entrepreneur to understand that they have to agree on each of these things, and it should be written in a very simple language so that there is no dispute at a later date. So I think most of the things are already covered. So one thing, value should be one seen by both the parties. Control metrics, there should not be no non-clarity about the control metrics, board seat, veto power, reserve item, etc. These things should be simply clearly written in the term sheet. Then economic model, whether there will be equity, direct equity, convertibles, what kind of discount or premium can be given, what will be the total anti-dilution right, etc., should be clearly mentioned. And if things are not going right way, what is the exit opportunity? So exit things should also be very much clearly written. If all these things are properly drafted, a commercial layman language term sheet can also be a very good document and which can help to in the drafting stage and in the final closing of the deal. And if it is faltering on any of these points, if one party changes its mind or want to take a exit opportunity, they will take the opportunity. They will take the benefit of the same. So that should be the main crux. That the term sheet, ideal term sheet should be basically clearly mentioning economic rights, operational workability and executability, and with not favoring any of the two party without with hidden words, hidden terminology which is not understandable by the other part, maybe entrepreneur, mainly by the entrepreneur, because they are new to these terms. So I think if that is happening, then it is a very good kind of document. That is all from my side. I think Varun has to say something more, which is left out because of my interjection in between. Anyway, you can continue, Varun. Yeah. I'm
Okay.
listening.
Okay.
I'm learning many of the things, new terminologies also. I think that iSafe is good, but good to learn.
Manoj, everybody is learning with everyone.
Yes,
Okay.
yes. That's
So,
great
so
thing.
yeah, yeah. So we have to just see what you can, because the purpose of these webinar is that you have done some transaction, they will understand. Then we have done some transaction, we will understand. I have given my understanding that don't start with the complete agreement. People are enthusiastic. Oh, this agreement I will prepare. They and junior always think कि पहले ना agreement बना लो. So
आज तो और आसान हो गया है because of chat GPT. You can put the things and there will be a template ready.
no, no,
So
that is
that
why no, that is a separate. But
yeah.
until unless your commercial understanding is not
Yes.
clear, I think transaction cannot move. And the most important thing is for any transaction, whether it's a term sheet or transaction or agreement, if it is not balanced, you will not succeed.
Yes.
But on some points you have missed out. Please cover this. Then I will ask question answer.
Sure, sir. I'll quickly cover those points. Firstly, thank you, Manoj sir, for providing such an important description and gist of everything in a very articulated manner. Thereafter, we wanted to cover convertible note because this is also recently has a lot of attention from the people and the entrepreneur community. Specifically, convertible note is issued by a DPIIT recognized startup, which is a company. While an startup can be recognized by DPIIT, can be in form of LLP or partnership as well. But this particular right or provision has been provided to a company structure only, wherein this kind of a note, wherein the investor does not have a lot of trust on the founders, that how the company will work, whether company is good or not. And initially they wish to invest in the company, but they want to get it converted at the next financing round based on a valuation cap or maybe at a discounted price or so on and so forth. And also it is not feasible for the founder and the investor to come out with a valuation at this stage when the product has not been launched or maybe for other reasons as well. So what they do, the company issues a convertible note. Convertible note is considered as a deposit under the Deposits Act. It is considered as a debt at the initial stage until unless it's get converted as per the terms of the convertible note agreement, which if gets drafted. So specifically, there are trigger events in the convertible note agreement, which specifically provide that what will be the interest amount, what will be the number of years that you can keep it as a convertible note and you have to convert it. And if before that particular event, the number of the period you want to convert it, what will be the trigger event? Can be next financing round, can be a, a lend a lending arrangement with bank which is exceeding 2x or 3x of the investment amount at this stage, so they may get repayment by the bank. There are certain criterias that that particular DPIT recognized startup has to fulfill before issuing these kind of a convertible note. uh, which are entity types. So for this is a DPIT recognition checklist basically. But for those kind of startups, they have to have a turnover for up to 10 years, 200 crores, and from 10 to 20 years, 300 crores in deep tech startups cases. And there is a startup recognition period. So the age of that particular startup has to be that in that particular recognition period to get a DPIT recognition. Other thing is business test, that there is an innovation, improvement, scalable, model is scalable, employment is there, wealth creation potential is there in the startup. Thereafter, there is reconstruction test, that the company has not been formed through splitting up of the shares or reconstruction of an existing business being showcased in some other manner. And thereafter comes the instrument fit, that this particular DPIT recognition may be a gateway, but it is not a badge that a particular startup will do good or bad. It is completely dependent upon on the company. What this DPIT recognition gives you is a recognition that you definitely have a pass through a reconstruction test, business test, and the turnover test from here. And now you can issue the convertible note that gives the comfort to the investor that this startup can do well. It has a fair amount of good structure that DPIT recognition requires. So moving on to instrument decision matrix, which will be taken care by Ravi sir from here onwards.
I'll
Ravi,
just wrap it up because we have to do question and answer. Sir, would you like to do question
I
and
think let's do the question answer. Manoj, Ravi, Minali, and Varun, please be ready. Okay. Manoj, is it not right? The term sheet is not a document; it is a DNA of the entire transaction.
Yes, I think it is a blueprint. Basically, it is the entire blueprint. If it is, even if it is written to be non-binding, I think this leads to the deal, whether it is
Okay.
funding deal or M&A. It leads to the deal. So it is very crucial instrument.
Okay. Minali, a poorly negotiated term sheet can be cured by well-drafted shareholders agreement.
Ideally, the term sheet should be drafted in a well-mannered manner, because, like, though the term sheet will get terminated when the definitive agreements do get executed, however, like, when it's still a drafting stage, so the founders or the shareholders may still negotiate, and still they will leave a room for negotiation if the term sheet is not very well drafted and doesn't provide any clarity.
Okay.
I
I
would
think
like to add
just
that.
close this PPT.
Hmm.
Okay.
Just wanted to add that in case the term sheet is not properly drafted or agreed and signed, and directly we rush to the main agreement, then there is a high chance that there will be further negotiation, continuous negotiation, and it is very difficult for lawyers to make the parties agree on something. So, and
Okay.
that makes the job of the lawyers very difficult, and most of the time it falters there.
Ravi, if there is a one-page agreement you have to make, then what will you insist? What should be included in the term sheet? And this is Ravi, you also, and Manoj, you also be ready. So if you have to give 5 points, noise remove.
I think one is that one must define what the transaction is, who the parties are, what their respective obligations are. And then, if the transaction is of executed nature, it is going to get completed on a milestone, then that's fairly simple. But if not, then anticipate as much as you can and provide a clear roadmap, because in one page you can't do much more.
Okay, Ravi, Manoj, what
Yes,
Ravi had missed
I
out?
think it is always very challenging to summarize everything in one page. But if the most important part is valuation, so valuation metrics should be crystal clear. Then economic model or structure, which kind of instrument would be used, and whether there will be anti-dilution or exit waterfall related things, that should be clearly mentioned. Then control related issues, and then path. what all are plus or minus allowed, like diligence, what size of monetary changes can happen due to diligence, or whether there is still room for negotiation because of the diligence. So that if these 4 or 5 things are clearly mentioned, I think then things can be worked out around it.
Okay. Now, Varun, do you think founder usually negotiate valuation, but they
Sir,
don't not
yes,
talk about the governance?
sir, I guess at the initial stage when the founder are looking to get the traction or in the market, they would like to have the best investor in their team. So they always look for valuation at the initial stage until unless they have somebody on their board who would tell them that you have to have a right people with them so that they can create value later on.
Okay.
So
Now,
that's the thing.
now we have to do the rapid round because there are so many questions which is created by me. So I will ask so quickly. Manoj, uh, um, do you think investor really invest in companies or promoters or
That
founder?
depends what is the stage of the journey of the company. If it is initial stage investment, it obviously investor bank upon the promoter founders and their vision and their commitment towards the business. After that, if it is a professionally run company and it is later stage investors are coming, then they will look at the model, profitability, business projections, whether it is sustainable, the team which has been created, all those things.
Okay. Okay. Ravi, what is the most important investor right actually? If excessive investor rights are there, then it will reduce value of the enterprise or increase.
It reduces
Why?
because in the bid to take more and more or extract more and more rights, damage is done to the business.
Okay, right. Okay, now, Manoj, what is the biggest mistake you have seen in term sheet in your corporate journey?
I think clarity relating to the valuation has been the biggest reason for breaking of any deal. I have seen many of the deal. I think 4 or 5 transactions have got derailed, M&A transaction especially, only because of the difference of opinion on the valuation aspect.
Okay. Minali, which clause create maximum dispute? I have asked Manoj the term sheet overall. I'm asking which clause you have found people are arguing more and more and discussing in paper and this. Which is the clause?
Representation and warranties and indemnity.
But this is not business. Okay.
Sir,
Yeah, this is your call. Varun, your call.
Sir, I could not hear you properly. Could you please come again?
Which clause create maximum dispute in term sheet?
Sir, at the term sheet stage, if your instrument structure is not decided, so that might create problem later on if your diligence finding later on tells the investor that you need to change the structure of
Okay,
the
No,
Ravi and
I
Manoj.
think what Minali has told is with respect to the agreement, definitive agreement, where
Okay,
lawyers negotiate. They
yeah,
negotiate a maximum on that.
I'm changing my question.
Yeah.
Manoj and Ravi, which clause after investment create disputes?
After investment, about exits and rights, that creates dispute. What is written on paper and what is being provided to the investor.
Manoj, your?
I think yes, Ravi is right. Most of the dispute post is the governance related, not relating to the valuation.
Okay, Minali, now the googly. Some clause which is looking very easy at the time of term sheet, but become biggest issue after 3 years or 4 years.
I would say lock-in, then like founder good lever, bad lever concept,
Okay.
and maybe exit.
Okay, Varun. Quickly, bhai,
Sir, I believe it's related to the exit rights because if they are not properly
Ravi,
stipulated.
fast.
Either anti-dilution, transfer rights, which is pertaining to exit, and one of the most important would be the economics of conversion. They create a lot of dispute.
Okay, Manoj.
Yes, if it is convertible instrument, yes, if the terms of conversion is not properly written, otherwise the anti-dilution rights, or even if it is not clearly written, down rounds happen, or well, business is not doing as it was agreed to be or anticipated to be, then it's create a lot of problem, because obviously down round is mandatory to run the business, and investor would like to protect his interest. So that is the most biggest dispute.
Okay, counter question I'm doing. Which commercial issue should never be postponed for definitive agreement? Something should be finalized.
This anti-dilution rights and exit related provisions.
Conversion and anti-dilution.
Okay, Ravi, what is the most commonly negotiated issue that people actually negotiate incorrectly?
I think valuation founders do not know, especially if you're not contributing cash and contributing by IPR and technology, you do not know your value. So you don't start at the right line.
Okay. Minali, term sheet should be negotiated for just funding round or company's entire growth journey.
Company's entire growth journey.
But how do I know? You as a founder has come to me and you are saying this is my project. This I will do this. I think this is creating some vacuum, so I will invest. But
if I am putting in money, even as an investor, the ROI will only be there if there is a growth in the company as a whole.
okay, I mentioned this, Varun, in my presentation that the good terms represent the good enterprise skill. So, can you think the good term sheet influence the next investor?
Yes, sir. I do think that having a good term sheet at the right cap table would influence the next funding round.
Manoj,
I think sir, term sheet would not be there to be seen by the next round investor. So I don't think it is a document which is anywhere relevant for the next round.
Okay.
However, as Minali was telling, in case of pre-seed or seed rounds, entrepreneur does not have any say. Most of the time, these seed investors have their own term sheet, and they have to agree in most of the cases, because their idea, the founder's idea, would not take off unless they get the money. And that time they have no choice but to agree to most of the things.
Okay,
Later
Manoj.
when the things changes, then the negotiation starts.
Okay, Manoj, how should founder negotiate today while keeping IPO or acquisition in mind?
I think for that, they should not agree to equity immediately. Try to go for ISAFE type of instrument or convertible instrument, where they can cap their valuation on the future events or future valuation. That would be the best.
No, Minali, if I'm giving a term sheet to you, then which are the 3 clauses first you will read first before reading the entire thing?
Okay. The 3 clauses that I generally read first would be anti-dilution, valuation. In case it's a convertible, then what are the formulas? And then I go to the rights that are available.
Okay. Manoj, you have advised, Ravi, you have advised. This is for both. What, after advising thousands of transactions which you have done, if you could remove one recurring mistake from every term sheet, what would be?
Recurring mistake. I think there is no specific clause which can be considered to be a recurring mistake. There may be language which can be corrected, which is generally kept as most of the things start with it is a non-binding term sheet given just expression of interest. However, practically everything is binding. Every action is binding. So that kind of thing should not be there.
Okay.
I may add, if I may add to what sir said. I think the difference between what is vague and what provides flexibility is a recurring mistake we would like to stop.
Right. Keeping vague is very difficult, very wrong thing to do.
Okay. Now super is wrapped around. So no, yes and no. One clause every founder misunderstands. Ravi.
Preemptive rights and anti-dilution.
Okay. One clause every investor over negotiates. Manali.
Valuation.
Okay. One clause lawyers always simplify. Varun.
Sir, investment amount.
Okay. One clause that should never be copied from another term sheet. Minali.
Terms of conversion.
Okay. One clause people ignore but later regret. Manoj.
People ignore. I think it is relating to anti-dilution only, exit clause.
Yeah. Okay. Ravi, one clause that protect the transaction more than the parties.
Confidentiality and exclusivity.
Very good.
Okay,
Interesting.
okay,
Yeah.
okay. So, friends, now it's a time to close. So, I'm just the favorite question which I have in the presentation I have given. My question is that are we negotiating to maximize one individual right, founder or investor, or we are negotiating to maximize the probability that the transaction will succeed, the company will grow? Because the best term sheet is not the one that wins every clause. It is one that gives the business the best chance to succeed. But now a counter question, Manoj. If there is a good term sheet, everything transaction, everything is good, even then business fails. What do you say on this?
Business can fail. Business, that is the entrepreneurship. Any business, any idea can fail. And that is not foolproof. So if it is a long-term journey, everything can fail, but there should be clarity. And obviously the founder should also know and investors should also know. So investor generally knows because they have the habit of investing in the ventures, but founders generally don't know. So they
Okay.
should also know what is the minimum value they can derive for.
Okay. Now there's a time to close. So I'm just normally asking views on this topic. Minali, I'll start with you.
Decoding term sheet is a very important aspect because, like, as Ravi sir, you and Manoj sir also mentioned, it's basically a preliminary document that essentially just captures the structure and the negotiation that has happened between the two parties. We wanted to capture like other aspects also. However, like the term sheet is like the terms that will flow in the term sheet are subjective to the subject matter. For example, like M&A term sheet, investment term sheet will differ from a joint venture term sheet. So it's really important, like not copy pasting from like any document that you see online. However, just to understand the subject matter and to see like what kind of business, the essential like the commercial aspect for which you are actually going to make the term sheet. So like to capture the aspects of those commercial matter and the subject matter is really important for any parties that are involved in the transaction.
Okay, Varun, 30 seconds only.
Yes, sir. Sir, it is quite important. Keeping in mind, we have provided the presentation for the seed stage or pre-seed stage founders. So generally, they don't have a cost to for providing it to for a lawyer or drafting a term sheet. So they generally need to know the basic concepts so that they can have the right document on the table. Hello.
Yeah.
He is finished within 30 seconds, sir.
He finished, sir. You are mute, sir.
You are mute.
Okay, Ravi, you.
I have 3 points to say.
Uh,
One is that what Manu sir said. Business may fail, but it should not fail for want of clarity. And term should not be, or an agreement or transaction should not be cause of business failure. That's number one. Number two, this is not chicken or egg conundrum. It's like there can be no butterfly without a caterpillar. So term sheet is the caterpillar and value is the butterfly. And caterpillar later on converts into butterfly. So maybe term sheet will not exist for future funding round, but the definitive documentation, which is the butterfly resulted from caterpillar, that will always be there. You can't erode it. It will be there in the history of the business. So protect both. You protect caterpillar, you protect the butterfly.
Manoj.
I think, well said, Ravi. I think that is very much important. But we have to. Only thing is, at the time of term sheets, corporates or founders does not understand the legal jargons. So keep the document very simple. Economic language, business language should be there, but all the terms should be as clear as possible. As I mentioned earlier, also various clauses are very important. So business, and in case of, specifically in case of investors, investment in the startups or new businesses, economic value creation for win-win for both investor and the founder is the key. If that is happening through the terms, then it is viable, then it goes well in the longer term. So that is the thing we have to see. Don't protect one party, it should be balanced from both the sides.
Absolutely right. And the term sheet when converted into the agreement, then agreement will survive, no doubt. But the term sheet is a stepping stone. So term sheet is not just the first document, it is an investment transaction. It is the first test of the relationship between both the parties, founder and the investor. Over the last 3 decades, which I have seen, one common reason why transactions get delayed, become expensive, or sometimes even fail also, and sometimes drag on. So the like drag on right and drag on light, so the agreement is also drag on. So it is really because of poor legal drafting. Drafting is not the culprit. The culprit is parties never fully agreed on something. And when they signed, even then they think यार मैंने कुछ नुकसान कर लिया. उसने कहा मुझे और पैसे मांग सकता था. A good term sheet should create clarity before documentation, number one. Confidence before investment. I and you are entering an agreement. Both should not feel cheated. Both should not feel कि मैंने सस्ते में दे दिया. They have a confidence and have a confidence in such a manner. Otherwise, if I am thinking that I have given you the deal on very cheap rate, or you are thinking that you have gained more money, then trust will lose. So alignment is more important before committing. So before signing any term sheet, every founder and every investor should ask just 5 questions. Have you agreed on the economics? Have we agreed on governance and control? Because that is the biggest issue after some time. Have we agreed on risk allocation? Because tomorrow risk will come. Who will be responsible? Business can fail also. Business can do this. So risk is also there. Where we agreed on the future roadmap. What is our plan? One investor is invested, but he's saying, I will not invest more money, and the growth required money. That's the other. Have we agreed on the exit strategy? In my opinion, all these agreements must contain exit clause. I am very good friend of yours, so we'll say, challe do. Lekin the agreement is not for the good time, agreement is for the bad time. So if the answer of all 5 questions is no, the discussion is not yet complete. Further discuss. So I will conclude my point of view. The best term sheet is not one that gives maximum right to one party, which I have told earlier. It is the one that leaves minimum surprises to both the parties, and the balance which Manoj has mentioned. Because at the end of the day, successful transactions are not built on documents. They are built on trust, clarity, and shared vision. Because if I have given a vision and you as an investor is ready to sail through with me, you can do this. So thank you very much to all for nice interaction and discussion on this very interesting topic, which is the founding stone of any transaction, and we have done justice. So thank you, Manoj, Ravi, Manali, and Varun for giving this, and thanks to all my participants, those who have participated. We will share this presentation to all of you. Till then, goodbye, and we will meet again on next Friday with a new topic, very complicated, very smart, very innovative, the takeover code program. See you till then. We'll meet again. Thank you.
Thank you, everyone.